My Lords, could I just start by giving some references that were requested? Lord Sales was asking for the cash schedules. They are Supplementary Bundle 1, page 93. The reference to Mr. Illett's report, so he's Primeo's quantum expert, is Supplementary Bundle 2 at page 3. Mr. Thompson, that was Primeo's investment management expert, Supplementary Bundle 2 at page 40. And I referred to Mr. O'Neill's evidence in support of their alternative investment claim. That is at MS 1607. My Lord, I was coming to the end of my submissions on this aspect of the way in which the SICA reversed the judge and saying his conclusion wasn't open to him on the facts. We do say that if the evaluative judgment that the judge made as to how the Primeo directors would have reacted to this new piece of evidence, namely the failure to issue the clean pre-withdrawal audit opinion, the evaluation of that was something that was fundamentally down to the judge, and the findings that he made were fully open to him. Just to run through some of the points that he obviously had in mind. First, by 2005, Primeo had been investing with Bilmes for over 9 years. Throughout that time, Bilmes had met all redemption payments. Madoff was held in high esteem as one of the founders of NASDAQ. Second, Primeo knew about and accepted the risks associated with single-source reporting and Bilmes' triple function. Dr. Fano did biannual visits to Bilmes, Judgment 309. Mrs. Cohen, Primeo's sub-investment advisor, we've not heard much about her. She was actually an important character. She had a very close relationship with Mr. Madoff. She was the doorkeeper. Like all others who dealt with Bilmes, they did not think that any of this posed an unacceptable risk. Judgment, paragraph 224. Third, Primeo had known from the time of the 2003 BA internal audit report that independent verification of assets was not possible. This was discussed at the June 2003 and May 2004 Primeo board meetings, as was the question of whether the assets actually existed. 4, Primeo had already bought into and accepted Madoff's desire for secrecy. We can see that from the judgment at paragraph 46 and 50. Fifth, the judge had heard the evidence of Judge Free, a former director of the FBI, who is the respondent's expert witness, and he gave evidence as to the highly sophisticated nature of the fraud. That's judgment, page 16. As the learned judge commented at paragraph 11, it was a highly sophisticated fraud, and the highly sophisticated nature of the fraud, quote, goes a long way to explaining how Madoff avoided detection for so long in spite of 3 examinations and 2 investigations by the SEC and 2 fraud risk reviews conducted by KPMG. Interestingly, even when the SEC was doing its investigations, it received documents from Mr. Madoff himself. They didn't go and take control of getting the confirms. He was that persuasive. As the judge commented at paragraph 14, the fake DTC position reports were highly convincing and successfully deceived both SEC examiners, investigators, and KPMG's forensic accountants. Madoff was a very persuasive fraudster who was adept at throwing people off the scent. Had he refused EY access to his site or specific documents, the judge would have been perfectly entitled to conclude that he would have done so in a way that did not excite suspicion, for example, by reference to his desire for secrecy. Sixthly, and importantly, the judge had heard extensive evidence from the investment management experts. One of the key issues that evidence considered was the wall of redemptions Primeo would have faced if it switched out of funds with a return like Bilmis into index-based equity funds with lower returns and higher volatility. And the judge refers to this at paragraph 250 of his judgment, quote, "For the reasons explained in the defendant's investment management expert's report, Mr. Lowe, it would have been very difficult indeed to do this, that switch, because any new manager would have had a different and inferior performance profile. No one could match Madoff's uniquely consistent performance." This evidence, which was never considered by Sicker, was clearly in the forefront of the judge's mind in the key paragraphs of his decision, paragraphs 266 and 267. And at the bottom of paragraph 266, the learned judge stated, in the context of what Primeo would have done in the light of EY's 2005 audit, open quote, "At the same time, they would have sought to find other alternative service providers and considered investing in one of the other Madoff feeder funds, such as Fairfield Century Limited, which was not engaged by any HSBC group company as their custodians and auditors." So, coming back to Lord Kitchen, the specific consideration was being given in the judge's judgment in relation to Fairfield Century. And this feeds directly into the judge's reinvestment decision at the end of the next paragraph of 267, where he says, "More likely, they would have reinvested in one or more of the other Madoff feeder funds which had not engaged any HSBC companies as custodian or administrator, thus avoiding any risk of mass redemption." And that's the reference to Mr. Lowe's evidence. Finally, there is the critically important point that we make at paragraph 255, subparagraph 1 of our case. That's at page 2342. That the judge was able to test how Primeo would have reacted to the fact of the inability to issue a pre-withdrawal audit opinion, and how that impacted their view of the fact that there was no independent verification of the existence of the assets. And the point we make in paragraph 255 is that the judge found that Primeo knew that EY's audit opinion was based on R2's custody confirms, which itself was based on unverified single-source information. So, in short, from 2005, Primeo knew that there had been no independent verification of assets, yet they continued to invest. The fact that Primeo was willing to do so provides powerful evidence, we suggest, supporting the judge's decision that EY's inability to produce a pre-withdrawal audit opinion, verifying the existence of the assets, but then producing the post-withdrawal opinion, would not have moved the dial in terms of Primeo's risk assessment of the situation. So, my Lord, the basic point is and just in terms of Fairfield Century, we refer to the evidence in relation to Fairfield Century in paragraph 2562 of our case, which is page 2435. My Lord, let me conclude. The basic point we say is this. In the light of all the evidence available to the judge, it was fully open to him to conclude that even if EY were not able to issue a pre-withdrawal audit opinion, on receipt of a post-withdrawal audit opinion, Primeo would still have reinvested through another feeder fund. And the type of counterfactual that lies behind the judge's conclusion is not difficult to envisage. Madoff would have told Primeo that he was not willing to give EY access to documents they sought because of his concerns about confidentiality. That would have raised no particular red flags. He would have then told them that he had no such difficulties with auditors of other funds, for example, PwC, who ordered Fairfield Century. He would have told them that they could redeem and that he would allow them to reinvest through another fund, such as Fairfield Century, and that would have been an attractive option to Primeo, as it would have avoided the mass redemptions Primeo would have suffered had it switched to a non-Bilmus-based investment. And, my Lord, whether or not SICA would agree with that line of reasoning is not the point. It was one that was fully open to the trial judge on the evidence that he had heard, with the nuanced understanding that he had, and he made that evaluative judgment. And we say SICA erred in holding that finding was not open to him, and we invite the board to overturn SICA on that point. My Lords, if I can just give you a few references in terms of the position of PwC and Fairfield Century. We refer to the fact that PwC were auditing Fairfield Century in our case before SICA. So that was footnote 150 at MS 2435. In terms of evidence that clean audits were still being issued in respect of other funds, we refer to what was called the optimal proceedings and invite the court to look at MS 1078, paragraph 26. This was before the trial judge, indicating that PwC continued to issue clean audit opinions in respect of Madoff funds. And during the closing, Mr. Justice Jones referred to the fact that other auditors continued to issue clean audit certificates. That is MS 1902. It's day 4, page 47. My Lords, can I now turn to the final aspect of our causation loss of a chance argument, and this is what we have termed the wrong counterfactual argument. And we deal with this at paragraph 258 to 262 of our case, and that's page 2436. And the short point is that SICA identified the wrong counterfactual in relation to the loss of chance case. It asked itself the question of what would have happened had R2 not issued the custody confirm. In fact, SICA should have applied the same counterfactual analysis to the new loss of a chance case as it did to the causation case in 2002. Namely, would Primeo have agreed to amend the administration and custody agreement? Now, if I can start by making good the proposition that SICA identified the wrong counterfactual, and then I'll draw out the significance of the point, which is that, contrary to what SICA thought, even in auditor causation, it does not lead to a loss of a chance case. So starting with the wrong counterfactual, and the genesis of the argument arises out of the point that SICA correctly identified in their judgment at paragraph 301, subparagraph 8, which is page 300. And at paragraph 301.8, SICA correctly observed that R2's provision of the custody confirm was not itself a breach of the custodian agreement. It was the consequence of a breach of the custody agreement. The relevant breach of the custodian agreement by R2 was its failure to recommend to Primeo that BILMIS was required to introduce and implement the most effective safeguards. So the relevant counterfactual is what would have happened if, in 2005, Primeo had recommended the available safeguards. But that, as we say, is the same counterfactual as arose in 2002, where the judge held and SICA agreed that the breach was not causative of any loss because Primeo would have agreed to amend the custody agreement to remove any responsibility for safekeeping of the BILMIS assets. So the point is a simple one. SICA correctly identified that the provision of the 2005 custody confirmation was not the relevant breach, but then inconsistently with this considered a counterfactual where the 2005 custody confirmation was not provided. In short, it applied the wrong but-for analysis.
Sorry, is the logic of that you say Primeo would have reverted just to relying on BILMIS? Is that the significance of amending the custody arrangements?
So they would have agreed to amend the custody agreement to remove reliance on to remove the obligation of custody. They would have considered reverting to the status quo, as the judge put it, of undoing the 2002 sub-custody agreement.
Okay.
So they would have gone back to the pre-2002 situation.
Was there a finding to the fact that that's what they would have done?
Yes.
Or was it simply that they would remove the responsibility of the custodian?
It was certainly that they would remove the responsibility of the custodian.
Yes, so the custodian and sub-custodian arrangement might have remained in place, but the terms of those agreements might have changed.
Yes. I will dig it up. Certainly my memory is that the judge says it would have been an attractive option to go back to the pre-2002 status quo, namely rip up the sub-custody agreement. I'm not sure he made a specific finding to that effect, but he describes it.
I thought that it was leaving the custodian agreement in place but amending it.
Yes, so that would have undoubtedly been the main approach. In other words, you reformulate the Primeo custody agreement in the same way as the Alpha custody agreement, because the Alpha custody agreement specifically accepted that there was no responsibility for the managed account assets. So what we say is that if the SICA had considered the correct counterfactual, SICA ought to have reached the same conclusions as it upheld in relation to the 2002 causation. Namely, Primeo would have agreed with the respondents to renegotiate the terms of the custodian agreement to make it clear that R2 had no responsibility for the BILMIS assets. R2 could still have issued the 2005 custody confirm, as that would not then have been a breach, and EY would then have still issued the 2005 audit opinion, which they then did. And my Lord Hodge, paragraph 253 of the judgment is what we had in mind.
253.
MS 141. Now, my Lord, Primeo's response to this limb of our appeal is in their reply case, paragraph 75 to 79, which is page 2339. And it's interesting that from that, it's clear that Primeo do not disagree with the core of our legal argument. They do not dispute that SICA identified the wrong counterfactual. As a consequence, they do not actually deny that SICA was wrong to treat this as a loss of a chance case. Rather, they make two evidential points, both of which we say are wrong. The first point they make is to say that the 2002 analysis does not carry through, I think is their phrase, to 2005, because the 2005 situation was different. And it was different, they say, because EY had made it clear that they could no longer rely on Freeling and Horowitz, but required independent verification of assets. However, in our submission, there's no force in that point, because as I have shown you, the judge rightly held that Primeo knew from 2005 onwards that its audited accounts were being signed off on the basis of custody confirms, which Primeo knew were based on unverified single source information as regards Primeo's investments with Bilmis. And Primeo were obviously not concerned by that fact, that their accounts were being signed off on that basis, because they continued to invest 100% with Bilmis. And in those circumstances, we say there is no reason to suppose that Primeo would not have amended the custody agreements in the same way as the judge found they would have done in 2002, so that R2 could continue to provide single source custody confirms that Primeo clearly found acceptable without that involving any breach on the part of R2. And the same reasoning applies to amending the administration agreement so as to continue to allow R1 to certify NAV on the basis of unverified single source information. So again, that was the judge's finding in relation to 2002. The second point that Primeo seek to make in its reply at paragraph 79 is that the directors would not have agreed to make the amendment in the positive 2005 counterfactual situation, and that even if they did, EY would not have acted on custody confirms provided where the issuer had no custodial responsibility. In fact, the alpha situation shows that both those propositions are wrong. And your lordships will recall that the alpha custody agreement expressly recorded that the custodian had no responsibility for managed accounts. It also contained no provision equivalent to the available safeguards provision in clause 16b. That's the point the judge makes in his judgment at page 92. Paragraph 92. And the alpha custody agreement is in the bundle at 567. In other words, the alpha custody agreement was already in the form Primeo would have been requested to agree to in order to exclude R2's liability to Primeo for the managed account assets at Bilmis. And your lordships know of the overlap in directors and investment managers between Primeo and Alpha. So Mrs. Farno is a director of Alpha and BAW. Also, you know her positions with Primeo. And your lordships know that Primeo invested in Bilmis through Alpha, knowing that Alpha had signed up to a custody agreement in those terms. So as a result, we say Primeo clearly knew of and was content with the form of the no managed account liability provisions in the Alpha custody agreement. The second point in relation to the directors, to the auditors, I would refer your lordships to the judgment at paragraph 232, the judge made a finding there that R2 issued custody confirms to EY for Alpha and Herald's audits for 2006 and 2007. And he returns to the point at paragraph 299 of his judgment. And the point being made here, in the context of the reflective loss argument, is that the situation in relation to Alpha and Primeo were practically the same. For the present purposes, the crucial fact is that despite the exclusion of custodial liability in the Alpha custody agreements, EY was signing off Alpha's accounts on the same basis as the Primeo accounts, namely custody confirms provided by R2, which both EY and Primeo knew were based on single source information. So in our submission, the fact that Primeo was happy to continue to invest through Alpha in that situation, and also the fact that EY was willing to sign off the Alpha accounts in that situation, shows that the 2002 scenario does directly transpose to the 2005 scenario. My Lord, I'm now going to move on to ground one of our appeal, which is in relation to strict liability. And we deal with this at paragraph 144 to 169 of our case. And Primeo's response is at paragraphs 2 to 18. And as you know, by ground one, we say that SICA was wrong to overturn the judge's finding that Primeo suffered no relevant loss for which R2 was strictly liable. So we're now back to strict liability and whether Primeo suffered relevant loss for which R2 is strictly liable. So just to reset the memory and to start with the no relevant loss point, as your lordships will recall, the judge at paragraphs 172 to 177 concluded that Primeo had suffered no relevant loss for which R2 was strictly liable. He held, rightly in our submission, paragraph 174, that the relevant loss was that which flowed from Bilmus's breach. But he then analysed Bilmus's breach solely in terms of Bilmus's obligation to deliver cash or equivalent securities. And he held that Bilmus had complied with those obligations. On appeal, SICA accepted Primeo's submission that Bilmus defaulted on its obligation each time it received cash from Primeo, which Primeo failed to safekeep, but used to fund the Ponzi scheme. And that's the SICA judgment at 195 to 197. The SICA also held that Primeo suffered immediate loss on each and every such occasion, and we see this at paragraph 217, because it was said that the value of the rights it obtained, namely Choses' inaction in a Ponzi scheme, were manifestly worth less than the value of the cash it provided. My lords, for even accepting that analysis of cash breach, if I can call it that, we say that SICA were wrong in finding that Primeo suffered any relevant loss for which R2 is liable. And my lord, there are 4 points that we make. I'm only going to speak to 3. My lord, the first point we make is at paragraph 147 of our case. And this is about the identification of relevant loss. And the starting point of the analysis is to identify the breach for which SICA found R2 strictly liable. And at paragraph 195, SICA accepted how Primeo put its case. And so SICA held that the relevant breach was the failure to safekeep the cash Primeo remitted to it. So that was the relevant subcustodial failure Blimis performed for R2 and for which R2 was strictly liable. Now, in our submission, the SICA erred because they then failed to apply the fundamental test of asking whether that breach caused relevant loss. And for those purposes, the SICA should have applied what Lord Nichols described in NICredit, MS 5431, as being the basic comparison. We set out the basic comparison at paragraph 147 of our case. It's simply a question of comparing the breach and the no breach situation. And the point that we make at paragraph 148 of our case is that even if Blimis had safe-kept Primeo's cash, Primeo would still have suffered the same loss. And this is primarily because of the nature of Primeo's rights against Blimis, which I don't understand to be in dispute. As we explain in paragraph 148, and this is not challenged in Primeo's reply, even if Blimis had safe-kept Primeo's cash by, for example, buying the specified securities, Primeo would still not have had any proprietary or security interest in those assets. It would only have had a contractual right that participated pro rata with all other customer claims in the subsequent SIPA liquidation of Blimis. So the point we make is that even if Blimis safe-kept Primeo's cash deposits, Primeo would still have been investing into a Ponzi scheme. Blimis would have remained free to fuel the losses on the Ponzi scheme using other clients' assets, and in consequence, Primeo would still have suffered the same loss in investing in the Ponzi scheme, and Primeo would simply have been left with the same unsecured pro rata claim in the Blimis SIPA liquidation. In other words, the safekeeping of Primeo's cash would have made no difference. The breach and no breach outcome would have been the same, establishing that there was no relevant loss. Now, from Primeo's written response, it appears to be the case that they accept that simply safekeeping Primeo's assets would have made no difference. They raise a new argument. This is their response, and we see this in their reply at paragraph 7. And what they say is that it's contrived to think that Blimis would run a Ponzi scheme in relation to all other investors, but would deal with Primeo's assets in good faith. And so what they actually say is, as a result, they say that the relevant no breach situation is where Blimis was not conducting a Ponzi scheme. Now, on that, let me just make two short points at this stage. First, it's not unrealistic to assume that Blimis might have safe-kept Primeo's cash or assets, but fueled the Ponzi scheme using other investors' cash. That's exactly what would have happened in the counterfactual had R2 required Blimis to hold Primeo's cash in a separate account. R2 couldn't require Blimis to safekeep or implement those safeguards as regards Blimis's other customers, so those other customers' assets would have been remained available to fund the Ponzi scheme. The second point is that the response makes clear that Primeo is not, in fact, seeking to hold R2 strictly liable for Bilmis's breaches as R2's subcustodian of Primeo's assets. It's actually seeking to hold R2 liable for the consequences of Bilmis's defalcations against all other customers, even though R2 knew nothing about Bilmis's dealing with those other customers. The duty R2 accepted to Primeo related to how Bilmis dealt with Primeo's assets, not how Bilmis dealt with other customers' assets. As a result, Primeo are wrong to say that the no-breach scenario is where Bilmis is not running a Ponzi scheme. Primeo's case, as accepted by SICA, and we see this at paragraph 197, is that the relevant breach was the misappropriation or misuse of Primeo's money. And Primeo cannot now seek to avoid the fact that that breach caused no loss by alleging a different breach and a different duty, namely an obligation to safekeep all of Bilmis's customers' cash. And stepping back, Primeo's real complaint is that the nature of the investments they chose to make in Bilmis gave them no security interest, which protected them from Bilmis's wider insolvency. But that's the consequence of the investment decision Primeo made. It's not the consequence of R2's breach. So, in short, we say the learned judge's analysis that the breach caused no relevant loss is correct, even when applied to the breach of the cash safekeeping duty identified by SICA. So that's the first reason why we say SICA was wrong. The second point that we make at paragraph 151 to 153 of our case, so that's at paragraph 2397, is that even if one accepts there was a breach of the safekeeping obligation every time cash was remitted, SICA erred in failing to find that that breach was rectified by the Herald transfer. At the SICA judgment, paragraphs 219 to 221, which we have at page 263, the SICA analysed the judge's finding that Bilmis had met its obligations through the Herald transfer. So the judge held that the Herald transfer satisfied the delivery obligation. So this is paragraph 219 to 223. The SICA rejected the judge's conclusion because they agreed with Primeo, and we can see this at paragraph 221, was that the relevant question was whether the transfer had nullified the loss. That's what SICA identified as the relevant question. Did the Herald transfer nullify the loss? And they held it did not. And in our submission, that's the wrong question. The right question, which SICA failed to ask, was whether the Herald transfer rectified the prior cash safekeeping breach. In our submission, it did. In terms of Bilmis's subcustodial delivery obligation, I don't think it's in dispute that R2 it's in dispute that Bilmes could discharge their safekeeping obligation either by delivering cash to Primeo or delivering the securities Primeo requested in lieu of the cash transfer. If Bilmes did either of those two things, they would rectify or make good any prior breach of the cash safekeeping obligation. Now, it was entirely Primeo's decision whether to ask R2 and Bilmes to deliver up cash or equivalent securities. And it was entirely Primeo's decision to decide what securities it wanted to receive in lieu of cash. It could have asked for the securities Bilmes had reported it was holding to Primeo's account. They were NYSE blue chip stocks. Instead, Primeo asked for its managed account assets to be delivered to Herald and to receive in return the shares in Herald. Those decisions were nothing to do with R2 or Bilmes. The decision to purchase shares in Herald was Primeo's and their investment advisors. Now, as we know, Primeo made, in one sense, a bad decision when it decided on the 2nd of August that it would not require Bilmes to deliver up cash, but would accept the equivalent value of securities. But as I've said, that was Pioneer's decision, and Bilmes complied with it. And in doing so, it brought to an end any cash safekeeping duties, and they rectified any prior breach by performing their delivery obligation, the delivery of cash or the securities requested by the customer in lieu. We outline, just briefly, and I don't think this is in dispute, paragraph 152 of our case and 153, that the Herald transfer was valid and effective, and indeed has been enforced by Primeo. I don't think I need to go through that. The point that Sicker made, namely that the Herald transfer did not nullify the loss, is with respect not to the point. It did not nullify the loss, but that was simply the consequence of the decision which Primeo made to ask for securities instead of cash. The point is that Primeo was entitled to ask Bilmes to discharge its safekeeping obligations in either of two ways, by delivering cash or by delivering the securities Primeo requested in lieu of cash. Primeo chose the latter option. Bilmes complied with those instructions and thereby discharged their prior safekeeping obligation. So, in consequence, we say there was no ongoing breach for which R2 could be strictly liable.
Did Bilmes deliver securities to Herald? Did they exist?
I'm sorry?
Did Bilmes deliver securities to Herald?
So did they deliver securities to Herald? Yes. In the sense that a book entry
about something that didn't exist.
Yes, that's right. But
okay.
Yeah. So, and I mean, obviously that was not known at the time. But in terms of how dematerialised securities are delivered, it is just simply by book entry.
Yes.
So one understands that would be a good reason for saying that it was Herald that suffered the loss in consequence of the transfer, and that's a point which underlay our reflective loss argument, that it's Herald that suffered the loss, and it's Herald that is the correct claimant.
But it was these were book entries about assets which didn't exist. There were no securities.
No,
There was money poured into a Ponzi scheme.
we understand that, and my point is, one accepts that it doesn't nullify the loss, but it was Primeo's decision to decide whether to ask for cash or securities. And the loss flows from that decision. They could have had their cash, they chose not to, they chose to take securities. That, in our submission, satisfies the delivery obligation. So it's asking yourself, what causes the loss? And in our submission, what causes the loss is the fact that they chose not to request cash, but to request securities. So, my Lord, that's our third point, the second point. The third point we make is the point that we make at paragraph 154 of our case, where we say the Herald transfer mitigated the loss of cash. I don't need to speak to that. I'll rely upon what I say in the case there. Can I move now to the fourth point that we make in the context of no loss? And this is moving to what's been described as the NICredit point. And we deal with this at paragraphs 157 of our case. And we say that SICA erred in finding that Primeo suffered immediate loss each and every time it remitted cash to Bilmus. So, your Lordships will have seen from the judgment how this issue arises, and the question of whether Primeo suffered loss immediately on remission of cash depends upon how you value the Bilmus credit covenant.
Well, there was no genuine credit covenant.
I'm sorry?
Well, I mean, it's just part of a fraud.
Indeed.
It's a fiction.
But that is to accept that you can use hindsight, and that's the...
Well, I don't think so. The money is paid to Bilmus. Bilmus steals the money. If you're lucky, you might get some money out if you try to redeem, if there happens to be money in hand that can be used to keep you company, to keep you happy, so as to avoid the balloon going up for the time being.
So I'm going to... I'll get slightly ahead of myself, but let me just sort of try and sort of flag up. In our submission, there's a critical difference between the test the law applies to identify when first loss is suffered, as opposed to how it assesses when damage has been suffered in terms of quantification and assessment. And the point is this: the question of when loss is first suffered is primarily of importance to the question of when limitation periods start to run. That's the typical type of situation one sees. So that's Law Society and Sefton, which we'll be coming to. In the NICredit case, it was a question of when interest ran from. But the question that the court is asking on the NICredit valuation of the credit covenant is when loss is first suffered. And we say on that analysis, you don't apply hindsight. So you don't say, well, you invested your cash in 2002, but in 2008, we know Bilmus was a Ponzi scheme, ergo, you suffered loss in 2002. And if that was right, it would advance the limitation period to a situation where there's a real risk that limitation would be running, even though the claimant didn't know that it had suffered loss. So that's one question. How do you assess when loss is first suffered? The second question, which is entirely different, is how does the court do an assessment of damages? And of course, on an assessment of damages, the court uses hindsight. So that's the Bulfer principle. Why guess when you can know? So take the wonderful case of the Golden Victory, the ship charter, and then the intervention of the Kuwait War. You use hindsight to say the Kuwaiti War intervened. We didn't know that at the time of breach, but at the time we come to assess damage, we know the Kuwaiti War intervened. We use hindsight to assess what was the actual loss suffered. So there's no doubt, and I entirely accept, that when you are doing an assessment of damage, you use the advantage of hindsight. That's BULFA. The question is whether you use hindsight when you're performing a different question, which is to assess when loss is first suffered. And that is what we say is the NICredit valuation. So that in our submission is the fundamental distinction that falls to be drawn when you're looking at these decisions. And I accept that possibly intuitively you would think, well, of course you use hindsight. And we think you do because that's what you do on an assessment of damage. But we're not doing that here. We're trying to identify when measurable loss was first suffered.
But surely loss is, you're looking to the reality. Is someone actually worse off after the event than before the event? And you do that for working out whether you've got a cause of action just as much as in quantifying the loss. In fact, if you've got a cause of action, you can sue on day one, even though it may involve looking forward to the future, but it may not.
Totally. No, I wouldn't disagree with any of that.
Right, but the reason I'm making that point is to query whether it makes any sense at all conceptually to make the distinction that you're drawing.
Well, in our submission, it does, and we'll come to NICredit very quickly. So in NICredit, Lord Nichols is...
just before you do, may I just ask you this? Yeah. Suppose the day after a cash payment is made to Bilmis, Primeo just sue, saying, actually, we're now deeply suspicious. We think you've misappropriated our money. Yeah. That's a loss. We want damages.
And what would have happened is that Bilmis would have been repaid. So
no. What would have happened would be if there had to be litigation of that issue, then and there, just supposing that you could do it that fast, the court would have to analyse the true position at that time, wouldn't it?
Well, the reality in that situation is that Bilmis would have just repaid the money.
It wouldn't. Sorry, just on what I'm putting to you, everything stops at that date. Just assume everything could be done litigation-wise, almost instantaneously.
So I would accept that, but then you've moved to the assessment of damage. So I accept that in terms of assessment of damage, everything can be brought into account. But if you were just asking yourself in the theoretical, has measurable loss been suffered in circumstances where all the impressions are that Bilmis is a cash-rich company and would simply repay on demand, we say there's no actual measurable loss. And in our submission, this is the point that the House of Lords was grappling with in NICredit. And in NICredit, Lord Nichols uses what he regards as being the simple case and the more complex case. And the simple case is where, as a result of negligence, you actually receive an asset which is diminished in value. So, for example, if you're acquiring a house and the solicitor has failed to discharge a charge, you can say, yes, I've suffered immediate loss at that point, because there is a perceptible difference in the value of the asset as it should have been, as against the asset subject to the charge. What NICredit is doing is asking, how do you determine whether you have suffered loss at a time where the credit covenant of the other party still appears to be good, and therefore, to all outward appearance, you've suffered no loss? And so, can I get straight to that? Because that, in our submission, is the is the critical point. And one picks this up from, just to make good the point that SICA regarded themselves as being able to use hindsight, that's perfectly clear. We see that from their judgment. And we say that their judgment on that is wrong for three primary reasons. First, they made no attempt to deal with the fact that Lord Nichols and Lord Hoffman both contemplated that there would be an open market valuation for the purposes of determining the value of the credit covenant. So could I take your lordships to NICredit? So we have that at MS 45435. And it's picking the point up at paragraph, at page 1632, so that's page 5436. And at subparagraph C, Lord Nichols said this: ascribing a value to the borrower's covenant should not be unduly troublesome. A comparable exercise regarding lessee covenants is a routine matter when valuing property. So that in our submission is quite clearly contemplating that there will be what could be called an open market value determined by reference to such information as was known or knowable through normal valuation procedures. So to take an example, valuing the credit covenant of, let's say, BHS, you don't take account of the fact that now you know that in actual fact it went bust 3 or 4 years later. You just perform the valuation on the basis of the information that is available to the market to see whether, taking that view, you can say that the credit covenant doesn't match the value of the cash. And
I mean, isn't this predicated on it being, in these examples, a genuine covenant? So you take BHS, that's a genuine covenant. It's not a Ponzi scheme. It's running its business. And yes, you look at how the market would value that genuine business.
But then
how does a market value a Ponzi scheme?
Well, the market doesn't know it's a Ponzi scheme. I mean, the hypothesis that you put of, but that's fine if it's as a valid business, but not if it's a Ponzi scheme, is to hypothecate that you can use hindsight. The reality is, if you're trying to value the Bill Mrs. Covenant in 2002, all you can see is a cash-rich company which constantly meets redemptions whenever they are made, and there's no reason to suppose that they won't be able to continue to do so.
I think what I'm hypothesizing is that one looks at the truth, the reality. Well, now, sometimes in your BHS example, it's not possible to have perfect knowledge of what the value of their genuine covenant is at a particular time, and then in standard ways you look to how a market would value that genuine covenant. But if you know that it's a Ponzi scheme, markets don't value Ponzi schemes.
I see that, but at the same time, it's simply accepting that you are not performing the valuation on the valuation date, in our case, when the cash was remitted in December 2002. You don't perform a market valuation by reference to the information that was available on that date. You take into account information which you only subsequently acquire in December 2008. And that's what SECA was saying, the Court of Appeal was saying, that you use hindsight. And my starting point is to say that if you look at how Lord Nichols is contemplating the credit valuation will be performed, we would say it's quite clear that he's not suggesting that you can use the benefit of hindsight. The second reason why we say Sicker fell into error, and we see this at paragraph 208 and 209, is...
Yes, since we're looking at page 5436 in my credit. Lord Nichols at C to D posits two cases. One where the borrower has no assets, and one where it does. And he seems to posit the case that if it's a no assets case, and the evidence shows that it's no assets, you value there and then. So why isn't that the Ponzi scheme?
Well, in the night credit case, for example, it was clear that loss was suffered immediately because the property borrowing company was a shell company with no assets. So on the basis of the information that was available as at the valuation date, you could say, performing an open market valuation by reference to the information that was then available, loss has been suffered. There are then the more complicated cases where there is an appearance of creditworthiness. And what in our submission both Lord Nichols and Lord Hoffman are recognising is that in many cases it may be difficult to identify that any loss has actually been suffered until there is a default. So can I ask your lordship to see...
I'm so sorry, this will be my last question on this passage. When Lord Nichols says sometimes the comparison will reveal a loss from the inception of the loan transaction, I mean, surely he's contemplating what you're calling evidence of hindsight, because people don't appreciate, they wouldn't make the loan if they appreciated that at the time. All right, so what I'm putting to you is, doesn't he mean the trial has shown that actually there was nothing there at the time of the transaction, it's just a complete loss from the start?
So I've made my submission that the typal example that Lord Nichols is looking at is simply where, on the basis of the information available at the valuation date, the company had no assets. It's obvious the credit covenant's worthless, and therefore you can say that measurable loss was suffered at that point. What your lordship is suggesting is...
Why would the lender have lent any money if that were obvious?
Well, one can see that in night credit that there was deception and everything else like that, but in terms of the financial status of the company, that was apparent just by looking at the audited accounts. But the situation that your lordship is postulating is that, and just to think through the consequences, and I'll come to Law Society and Sefton, because I'll suggest that in the context of contingent losses, it's quite clear you don't apply hindsight. I'll come to that in a moment. The situation that you're positing is December 2002, the transaction is entered into. Your borrower, Bilmis, looks perfectly solvent. 10 years later, it's discovered that it was actually a Ponzi scheme. Now, on your lordship's analysis, if you apply that to the question of when loss is first suffered, you will come to the conclusion that the limitation period started running in 2002, because the occurrence of actual damage will start the tortious limitation period running.
Yeah, that's how limitation periods work, isn't it?
Well, it does in the context of physical damage. So, of course, in the case of latent damage and
well, surely it does so in the context of any damage. If there is damage, you've got your cause of action, it runs.
The difference is that in the case of damage to the property, there is actually physical damage. You might not know about it, but there is physical damage. And so if anybody was doing a valuation, if they found that just using an open market valuation, and the surveyor went round and found the defect that nobody previously knew about, there was actual loss suffered. So that's the simple example that Lord Nichols is raising. The more difficult question is where you've got the credit covenant. And in our submission, Lord Nichols is indicating that you still just use the same open market valuation techniques, looking at the information that is available and knowable. You don't use hindsight. And, my Lord, can I just remind your Lordships that one of the points that both Lord Nichols and Lord Hoffman was making was that for so long as the credit covenant is performing, it may be that no loss is suffered. Now, if you use hindsight, that wouldn't be the case, because you would simply be saying, well, we look at the position come trial, we know that 5 years later he defaulted, and that was a consequence of the fact that he had insufficient assets. You carry that back, and that shows that you suffered first loss. So, my Lord, we say the fact that both Lord Nichols and Lord Hoffman are saying that while the credit covenant is performing, it may be that there is no loss, is indicating that you do not use hindsight. And, my Lord, I mean, maybe I can try and take the debate forward by looking at Law Society and Sefton.
I didn't want to divert you from any passage in Lord Hoffman that you wanted to show us in my credit.
No, I'm...
Sorry.
Your Lordship will have seen from the case what we regard as being the critical passages in Lord Nichols' judgment and Lord Hoffman's judgment.
Yes, thank you.
And we've made our two fundamental points of criticism of the Sicker judgment. Three, just to encapsulate. Firstly, we say they gave insufficient attention to the fact that Lord Nichols was contemplating an open market valuation in the same way as one would do a evaluation of a credit covenant. We say that at paragraphs 208 and 209, Sicker was wrong to reject the submissions made by reference to Lord Nichols' speech, that it would make no sense if you could use hindsight, because then it wouldn't be difficult to perform the credit valuation. You would know what the situation is as and when the matter comes to trial. And then the third point we make is that Sicker were wrong in the second part of 209 to suggest that the passage they quote from Lord Nichols threw any light on whether hindsight could be used. And we'd invite your Lordship to look at the context of Lord Nichols' comments. And there he is actually talking about assessment of damage. My Lord, let me move forward to the Law Society in Sefton, because in our submission, the Law Society in Sefton is an interesting and illuminating case. And in terms of whether loss has arisen in relation to a contingency, it's quite clear you don't use hindsight. Now, just very quickly, just to remind your Lordships of the facts, oh my goodness me. I'm sorry, I've just seen the time. In 1918, between 1989 and 1995, accountants negligently reported to the Law Society that a solicitor was complying with the solicitor's accounting rules. They negligently failed to detect that the client money was being stolen. The solicitor's fraud was discovered in 1996, and the Law Society intervened in the practice. Now, the misappropriation of client monies between 1989 and 1995 exposed the Law Society's compensation scheme to the risk of claims. The first of those claims was made in 1996, and over the following 3 years, the Law Society Compensation Fund paid out substantial compensation. On the 16th of May 2002, so within 6 years of the first claim being made, the Law Society issued proceedings against the accountants, alleging that they were negligent and the Law Society had relied upon their reports in not intervening earlier. The Law Society's contractual claim was barred. The defendant accountants also said that the Law Society's tort claim was barred, and they argued that the Law Society suffered actual loss on each and every occasion the solicitor stole money between 1989 and 1995, because that would lead to a contingent claim on the fund. And if I can take the board to paragraph 9 of Lord Hoffman's speech, which we have at paragraph 4, at page 4812.
Here, this case is reported in the appeal cases.
I'm sorry. I'll just take this very quickly. Paragraph page 4812. If I can just ask the court to read paragraphs 9 and 10, that's summarising the contentions of the parties. So it's effectively, did the contingent liability give rise to an actual loss when the money was first stolen? And Lord Hoffman is saying that it's only contingent because the monies might have been repaid or the client may not have made a claim against the Law Society. Lord Hoffman stated that although a claim might be likely, the Law Society could not have started a claim on that basis. And then, if I can ask your Lordships to read paragraphs 17 and 18 of Lord Hoffman's speech. So this was relying upon the Australian case of Wardley and Australia, Wardley and State of Western Australia. And as your Lordships will see, in the eyes of the law, a contingent loss is not an actual loss that causes the limitation period to expire. And in our submission, that very simple and straightforward, the very simple and straightforward point we make is that the law does not use hindsight, contrary to the Sicker's conclusion, to determine when loss is first suffered. So the law doesn't reason, as Sicker would say, well, we know with hindsight that the monies were not repaid, and we know with hindsight that a claim was made, and therefore actual loss was suffered when the monies were first stolen. And so in our submission, Law Society and Sefton, well-established law, that actual loss for limitation periods doesn't arise on the incurring of the contingent liability, but only on the occurrence of the contingent liability, makes clear that for these purposes, the law doesn't use hindsight. So, my Lords, that's the point that we would say. We say that flows entirely from the analysis in Night Credit. We can see that in Law Society and Sefton, they're analysing the decision in Night Credit. We say it's entirely consistent with what one sees in Night Credit, namely that when you are considering when loss is first suffered, you don't use hindsight for the purposes of working out when limitation period first starts or when loss was first suffered, for the purposes of saying when interest ran in the case of Night Credit, or we would say in this case, you don't use it for the purposes of establishing when loss was first suffered, for the purposes of applying the reflective loss rule. So, my lords, that's what we say in relation to Law Society and Sefton. I was going to take your lordships through DNB and Bullock, which is the other case that the Court of Appeal referred to. Just very quickly in relation to that, and I'll ask your lordships to look at it separately. In DNB and Bullock, we say that the valuation that Lord Justice Robert Walker approved didn't use the advantage of hindsight. There were really three pieces of valuation evidence: the fact that Mr. Bullock had gone self-employed, the fact that there was a new charge over the property. Those were all facts which were known or knowable at the valuation date. The only question is in relation to certain debts which were revealed on the subsequent bankruptcy. And what we say in relation to those is that the court was only taking into account such of those bankruptcy debts as one could infer had been incurred at the date of the bankruptcy. My lords, there are one or two passages in Lord Justice Robert Walker's decision which, unless you read them carefully in context, can look as if they are saying that you perform an actual value, a true valuation, an actual market valuation, looking at all subsequent events. Your lordships need to look carefully at how Mr. Denman, who was the expert for the defendant, was defining what he regarded as being an open market valuation. And what he was saying is that if you are valuing a book of debts, you don't look at the credit standing of each of the individual creditors. And when Lord Justice Robert Walker is saying you don't perform an open market valuation, he's actually saying you don't perform the open market valuation Mr. Denman is suggesting, which is by reference to the valuation of a book of debts where you don't look at the creditor's credit covenant. So it is slightly confusing. So that has to be read quite carefully, but we do say that DNB and Bullock, which is before Law Society and Sefton, gives no support for the fact that you use hindsight in trying to determine when loss is first suffered, and any such conclusion would be entirely contrary to the reasoning of the House of Lords and Law Society and Sefton. So, my lords, those are our submissions in relation to no relevant loss and no immediate loss. And, my lords, it is an important point. I mean, this is not a point which is just of importance to these parties. It is actually a sort of fairly fundamental point in terms of what is going to trigger the start of limitation periods. So it is obviously a point of wider significance, and we say clear guidance as to the approach of the law is provided in Law Society and Sefton. My lords, can I now move on to the next issue, which is levels of contributory negligence? And this is issue 9 of our appeal. My lord, the question here is what is the correct percentage for the finding of contributory negligence? And we deal with this at our case at paragraphs 289 to 301, and Primeo deal with it in their reply case at paragraphs 104 to 114. My lords, I don't think there's any dispute between the parties on the correct legal approach to appeals on contributory negligence. At our case, at paragraph 293, which is page 2246, we summarise the position as derived from the Supreme Court's decision in Jackson and Murray. The key propositions are well known and not in dispute. The assessment is by reference to relative blameworthiness and causative potency of the plaintiff's fault as against the defendant's fault. There's no demonstrably right answer, as the factors the court takes into account are incapable of precise measurement and are fundamentally incommensurable, and that absent an identifiable error, an appeal court should not interfere with the judge's finding unless it exceeds the generous ambit within ambit within which reasonable disagreement is possible. So your lordships will have seen at paragraph 319 of the judge's judgment that the learned judge concluded that Primeo was to a very substantial degree the author of its own misfortune. He then summarises what he regards as being the key aspects of Primeo's fault. So that's the plaintiff fault aspect of contributory negligence. The earlier part of his judgment has obviously dealt in very great detail with the nature of R1's contractual obligations as administrator and the nature of those administration breaches. So that's the defendant's fault aspect in the contributory negligence equation. Now, weighing those two considerations against each other, the trial judge came to the conclusion, reflecting his view that Primeo was to a very substantial degree the author of its own misfortune, that it would be just and equitable, so that's the test, to hold Primeo 75% responsible for its own damage.
And is that against R1 or against R2?
I'm sorry, I should have clarified. This is just against R1. The situation is that the judge, let me deal with this now, the judge found that contrib was not available as a defence on the claim against R2. SICA overruled them on that and said that it was available as a defence. And SICA didn't actually say what the contrib level would be against R2. They found that contrib against R1 should be reduced to 50%. And one can see from my learned friend's reply skeleton that I think we both accept that SICA intended that the same contrib level should apply against R1 and R2. So let me jump back to R1. And the SICA's decision on this is at paragraphs 507 to 508, and it's at page 370. And the entirety of the Court of Appeal's reasoning is at paragraphs 507 to 508, and in our submission that comes nowhere near establishing that no reasonable judge could have concluded that Primeo was very substantially more responsible than R1 for the loss that it suffered, such that SICA was entitled to substitute its own judgment of 50%. So can I turn to the Court of Appeal judgment at paragraph 507? And there are really three strands to their reasoning, although it might be said that the first two are really just the same one. First, they light upon the fact of R1's status as a professional administrator. Second, they say because of R1's contractual obligations, and SICA say that R1 was given the specific task of monitoring Bilmis and determining the NAV, and that it did so without having verified the existence of the assets. So they're focusing on the nature of the contractual obligations. And then the third point that they make is that they say R1 did not make Primeo's board aware of HSB's concerns, and indeed during the board meeting in 2003 and 2004, Mr. Fielding provided reassurance to the Primeo's board. So can I just take each of those strands in turn? On the first point, obviously there is no dispute that R1's status was that of a professional administrator. But on the other hand, that was well known to the trial judge, who had spent 4 months considering the performance of those duties, and there's no proper basis for suggesting that this was not factored into the judge's evaluative judgment on contributory negligence, as all of the earlier part of his judgment. In any event, there is no per se rule that because a defendant is a professional service advisor, contrib can never be higher than 50%. The analysis is obviously much more fact-sensitive than that. And at paragraph 296 of our case, this is page 2447, we refer to two cases where findings of 75 and 80% contrib have been made on claims against professional service advisors. So that's the first point. There's absolutely no reason to think the judge hadn't taken this into account, and it doesn't lead to the conclusion that contrib should be reduced to 50%. On the second point, the nature of R1's contractual tasks, I'll take those in as if they were two strands. First, it's not the case that R1 was given the specific task of monitoring bill miss. Now, if all SICA meant by that is that R1 had obligations in connection with certifying NAV, then I don't take exception to it, and that's obviously taken into account by the judge. As we made clear at our case at paragraph 297, the trial judge had rightly held that R1 had no obligation to provide risk management advice and fulfilled no formal role in identifying or preventing fraud. But even if you're against me on that, we submit it's quite clear that Primeo's directors and investment advisors did owe obligations to monitor bill miss. It was Dr. Fano who visited twice in New York. Dr. Fano was the gatekeeper, and your lordships have seen and read about the BA internal audit report in 2003 and the Pioneer report in 2007. So if there was a breach of a monitoring obligation, a judge would be perfectly entitled to conclude that Primeo was more at fault, or at least equally at fault. The real nub of the allegation is the second point, that R1 certified NAV without having done anything to verify the existence of the assets. But in our submission, the SICA seemed to have taken no account of the fact that in that regard, it could be said that Primeo was heavily at fault in the discharge of its obligations. The point is that the judge had found that Primeo and its investment advisors, who were fellow market professionals, knew that R1 was preparing NAV on the basis of single source information. And turning to the 2005 and the provision of the sub-custody comp firms, Primeo knew of EY's concerns, but they discouraged EY from visiting Madoff. And as regards the custody comp firms, they knew that they were being provided on the basis of single source information, and that the audits were being signed off on that basis. And of course, it was the directors' obligation to satisfy themselves as regards Primeo's, as regards Primeo NAV, because it was the directors who ultimately certified and were under the statutory obligation to keep proper books and records. So again, because of the equivalence of knowledge, we say that a judge would have been perfectly entitled to conclude that R1 and Primeo were equally to blame for the inaccuracies in the NAV certification. They both made the same inaccurate risk assessment. In respect of the third point that SICA rely upon, we say that's simply wrong. And we make a factual and a legal point. As regards the factual point, the judge concluded that R1 did not conceal anything, because Primeo and its advisors were already aware of the risks posed by single source reporting, and that Mr. Fielding did not provide false reassurance at the board meeting. So again, in your lordship's own time, I'd ask the board to reread paragraphs 88, 98 to 100 and 240. As regards the legal points, we say none of that should be taken into account in assessing the defendant's fault, as the judge held that there had been no gross negligence. And the fact that the Contributory Negligence Act specifies that the Act shall not operate to defeat any defence in contract means that this falls out of account. So, my Lord, the specific points that SICA made were, we would say, firstly, either known to the judge or were wrong, or when viewed in context, were areas where Primeo was at fault to an equal or greater extent. What in our submission SICA failed to take into account, and which in our submission fully justifies the conclusion that Primeo was substantially the author of its own misfortune, is the fact that despite all Primeo's directors and despite all that Primeo and its investment directors knew, they continued to place 100% of their investments with Primeo. Sorry, with Bilmus. So rather than diversifying the classic way of reducing risk, they decided, knowing the risks, to put all of their eggs in one basket. Now, in terms of what caused the amount of damage suffered by Primeo, that was the most causatively potent and blameworthy act. Knowing the risk, Primeo decided to place all its money on black. The scale of the losses was aggravated by the all-in-one baskets decision. And that is why we say the judge was absolutely right to conclude that Primeo was substantially the author of its own misfortune. It was that decision that acted as the multiplier for the damage that Primeo suffered, and that was rightly reflected in a finding of 75% contributory negligence. Now, whether or not that would have been SICA's conclusion if they were making the decision de novo, it's not the point. We say it was not open to SICA to say that it was a decision that no reasonable judge could have reached. We say it's a perfectly rational, evaluative judgment that was fully open to the judge to make, and having heard all of the evidence, that was his conclusion as to what was just and equitable in the circumstances. And so on that basis, we say that there was no justification for SICA to interfere in relation to R1, and that in reality the judge was in a vastly better position than SICA, having sat through a 4-month trial to make the complex evaluative judgment that has to be made on an assessment of contributory negligence. My Lords, let me just turn very briefly to contributory negligence on Primeo's claim against R2.
Just before you
yes.
do that, as I understand the Court of Appeal's judgment, if one reads back a little bit before 507, 508, to Primeo's submissions, part of the submission was that paragraph 319 in the judge's judgment didn't seem to bring into account the points which the Court of Appeal then pick up, and I wonder whether you had anything to say about that.
Well,
yes. Just for observation, paragraph 319, page 178 in the judge's judgment, yes. He doesn't seem to balance. He seems just to point to factors relevant to Primeo.
Yes, because in our submission, the judge has been dealing with the fault, the defendant fault, in the previous 150 pages of the judgment. So that's what all of the earlier part of the judgment is about. And one sees from Murray and Jackson recognition that judges often express their views on contributory negligence relatively shortly, and that's not a point to be criticised. That's particularly the case here in circumstances where the judge had found that there was actually no liability. But taking a balanced view, reading the judgment as a whole, it's clear that the judge knows how you perform the contributory negligence balance. You look at plaintiff fault and defendant fault. We see in 319 the aspects of plaintiff fault. All of the rest of the judgment is the judge's conclusions on defendant fault. He took all of that into account. In our submission, the multiplier effect that I've been referring to fully explains why he reached the conclusion of 75%, because that was the fuel on the fire, investing 100%. My Lords, in terms of contributory negligence against R2, we say that if the judge had not erred in rejecting the defence of contrib on the claim against R2, those same factors would have led him to conclude that Primeo's recoverable damage against R2 should be reduced by the same amount. And Primeo's reply case at paragraph 11, page 2347, seems to implicitly accept that the findings on the claims against R1 and R2 should be the same because they're driven by the same factors. But as I've said, Primeo said the appropriate assessment is 50%.
Well, I suppose formally, the 50% in relation to R2, the first assessment made of that is in fact by the Court of Appeal.
Yes, that's correct.
Right.
Yes.
And I mean, are you saying that they went wrong in principle so far as that's concerned?
My Lord, yes, we would do. For the reasons we've already identified, one can see that one can see what their reasoning on contrib is from what they say on R1, and it's reasonable to suppose that they applied the same reasoning to R2. So that reasoning we say was wrong for the reasons that I've already given. There are two additional factors that we bring into account in respect of R2. First, you will recall that R2 was not the custodian of Blimis's managed account assets from inception, 1994 to 2002. During that 8-year period, Primeo got itself comfortable with Blimis self-custodying the assets, despite the risk posed by triple function. And it was only in consequence of the execution of the 2002 sub-custody agreement that R2 became liable for those assets. But the 2002 sub-custody agreement was not executed at the initiation of Primeo because it felt the need for additional protection offered by a professional custodian. Primeo was essentially the lucky beneficiary of what can now be seen as being the ill-advised decision by R2 to execute the sub-custody agreement. And the trial judge recognised that, paragraph 319, restructuring the custodian agreement in August 2002, whereby Blimis became sub-custodian of R2, did not result and was not intended to result in an operational change, and the risk therefore remained unchanged. So Primeo's protestations as to the importance they say they attach to having R2 as a custodian have to be viewed in that light. The second point that we make, which reinforces that point, is the judge's finding, paragraph 253, in the context of the 2002 causation case. The judge found that 2002 causation was not proven because he held it would be an attractive option for Primeo to revert to the status quo. The judge held, and it's in that context that he said it'd been attractive to terminate the 2002 sub-custody agreement and amend the 1996 custodian agreement to make it clear that R2 had no responsibility for the managed account assets. So again, once again, in our submission, that puts into the correct context the suggestion that Primeo was relying on R2's risk assessment. So, my Lords, it's on that basis that we say that the judge's finding of 75% contributory negligence was one that was fully open to him as the trial judge, and a finding of 75% contrib should be reinstated against R1 and ordered in respect of R2. My Lords, I'm just going to have to move just very quickly to just make a few key points on our other issues. My Lords, turning to limitation and section 37, we deal with this at paragraph 272 to 282 of our case, and Primeo's reply is at paragraphs 87 to 104. I will summarise the key points and respond to some of the points made by Primeo. Your Lordships will have seen from the Sicker judgment at paragraph 458 that the issue is whether, as the Sicker held, by virtue of being an independent contractor, Bilmus was an agent within the meaning of section 37. And in short, we say that Parliament was most likely to have intended to refer to the normal meaning of agent, which in both legal and everyday language means a person appointed by a principal to act on their behalf, cloaked in their authority, so that the third party can do business with the principal via the agent. And if the Parliament had intended to extend the meaning of agent to include subcontractors, which is a different context, a different concept, the draftsman would have drafted the provision to read agents and subcustodians or independent contractors. Now, in their reply at paragraphs 93 and 94 at page 2341, Primeo seek to defend the Sicker judgment on a narrower basis, namely that agent includes all subcontractors. So where C agrees with A to fulfill in whole or part A's contractual duties to B. But at points in its case, Primeo also seems to place reliance on the further condition that A remains liable to B for C's performance under the contract. Now, this construction is narrower than Sicker's, only insofar as it's limited to persons engaged to perform others' contractual duties, and it's silent on persons engaged to fulfill any other private law duties, for instance, duties of care in negligence. And in our submission, it's not clear how Primeo can justify limiting the meaning of agent to the contractual scenario, where Section 37 is concerned with deliberate concealment in a non-contractual environment as well. In terms of the meaning of agent, in Section 37, we say that applying the familiar principles of construction, agent means a person appointed by consent to act on another's behalf to affect legal relations with the third party. And that does not include independent subcontractors with no such authority.
But might it not include Bilmus? I mean, isn't Bilmus an agent for performance of R2's obligations so far as the sub-custodianship is concerned?
It is performing those obligations, but it's not an agent in the sense of it has legal authority to affect legal relations with third parties. So it's performing a contractual obligation, but as a subcontractor.
But isn't what it does affecting the legal relations between R2 and Primeo, a third party? Because if Primeo said to R2, what have you done with my assets? R2 would say, here's this company, Bilmus, which is looking after them carefully.
But you could say the same about all independent contractors, that if the independent contractor performs the work negligently on behalf of the builder, that will affect the builder's obligation towards the purchaser of the property. So the mere fact that there is a performance of that function, we say it is not sufficient. And that's the point that we make, that Bilmus does not fall within the established meaning of agent because it was authorised to perform R2's contractual duties. And it doesn't have the power to affect R2's legal relations with Primeo. And that's the meaning of affecting legal relationships with third parties, and we refer to Bousted on this at Chapter 1 at subparagraph 4. It's meaning the power to contract or to terminate a contract, to transfer or dispose of property, or similar powers. Merely agreeing to do something for someone else does not make you an agent in the strict legal sense. So, my Lord, might I ask the President if I could extend for 15 minutes tomorrow so that my reply time would be reduced to 45 minutes?
Yes, that's a matter for you, Mr. Gillis.
I'm obliged. The second point that we make at paragraph 280 of our case is that the concept of an independent contractor employed by SICA and the word agent used in section 37 are different concepts applied from different areas of the law. And an independent contractor is a tort law concept based on whether the contractor is carrying on its own business. And the degree of control that arises from that. The agency arises from the agent's and principal's consent because of the power to bind the principal, and that gives rise to fiduciary duties. And the independent contractor owes no such duties. And so given that, we suggest that it's not credible that the draftsman intended agent in section 37 to be expanded by reference to the concept of independent contractor. And that, in a sense, is going back to the point I was making earlier. The mere fact that you employ or engage somebody to perform another's contractual duty tells you nothing about whether that person is an agent or a subcontractor. The third point we make at paragraph 282 of our submissions, we make the point that the natural meaning of the word agent, where it appears in other sections in the statute, does not include non-agent contractors. So sections 29 and 30 in the Limitation Act is about acknowledging debts or title, which necessarily means someone able to bind the principal. And section 32(1)(a) concerns actions based on defendant's fraud, and generally a defendant will not be liable for an independent contractor's fraud. So there are 2 points that we make out of that. Where agent is used in other sections of the Act, it's used in a sense which indicates it's an agent properly so called, an agent with power to effect legal relations on behalf of his principal. And then secondly, if you incorporated within the concept of agent an independent contractor for the purposes of section 32(1)(a), it would have the effect of making the defendant liable for the fraud of an independent contractor, which is not the established law. The fifth point that we make is, and this is a...
Just on that.
Yes.
I mean, obviously, you're not making them liable for the frauds of the contractor. It's just a question of whether the contractor's fraud serves to postpone the running of the limitation period. And might it not be said that if the principal contractor has chosen to appoint someone else to perform its obligations vis-à-vis the client, that it wouldn't be unreasonable, at any rate, to say that they've taken the risk of what their subcontractor does in relation to its performance of those obligations?
Well, that comes to the policy decision, which lies at the heart of this, because there is a balance to be struck between plaintiffs' interests and defendants' interests. And what we say is that looking at Section 37 of the Act, and this is what we say is the policy that lies behind the Act, time is only postponed where it's in relation to an agent, not an independent contractor. And that's a reasonable and principled approach to take because of the additional control that a principal has over an agent properly so called. And it's because of the nature of the relationship between the principal and agent properly so called, which is so much closer and gives rise to fiduciary duties, that in respect of an agent, it's regarded as being appropriate to postpone limitation. But in the context of an independent contractor, where there is no such close degree of control or connection, legislation has drawn the line. And obviously the line has to be drawn somewhere. And what we can see in terms of parliamentary intention is that the line has been drawn at the point of agent. So that's the point that we make at 285 of our skeleton, that the Parliament was balancing justice to the claimants with the policy aim of limiting and preventing stale claims. My Lords, in terms of the two authorities that are relied upon, the two authorities are Applegate and Moss and King and Victor Parsons. And in relation to both of those cases, we say that the observations regarding the agency point was obiter. In Applegate, the evidence was that the builder had agreed to, the independent contractor had agreed to the changes that were to be made to the foundations by the builder. And in King and Victor Parsons, the court held that the builder knew of the fraud. So we say that the dicta were wrong for the reasons that we have given. The judgments contain no proper analysis of the agency point, and the point that we make in the case is that the cases have generally not been followed as establishing that all independent contractors are agents for the purposes of limitation. My Lords, if I can move very briefly to the administration breaches. And I don't have time to make full oral submissions in relation to the administration breaches. We rely upon what we said at paragraphs 186 to 227 of our case. And in the short time I have, there are just three key points that we would make. The fundamental criticism that we make of the judge is that he found R1 negligent from 1996 because it was performing reconciliations based on single source information. But that was not supported by Primeo's expert, Miss Bader. Her case was that R1 only became negligent from 2002. Now, one might ask, well, why does that really make a difference? It makes a difference because the judge took the attitude that a multi-source reconciliation was a sine qua non of a competent administration. But the point is that that had not been Miss Bader's case. Your lordships have been referred to various parts of Miss Bader's case, but if that was what Miss Bader was saying in her expert's report, her expert report would have been fundamentally different. It would have been saying R1 was negligent from the word go because it is the ABC of administration. That reconciliation has to be done by reference to multiple sources. That was not her case. Her case was that R1 was negligent once it developed concerns or should have developed concerns. And she said that was in either 2002 or 2004. And so the fundamental point is that the bedrock of Mr. Justice Jones's reasoning of multi-source reconciliation as the sine qua non of administration was not a case that was advanced in the expert report of Ms. Bader. And we refer to authorities which indicate how careful a judge has to be in reaching conclusions on professional negligence without the assistance of expert evidence. This was one of those cases. The judge may have extensive background knowledge, for example, as regards solicitor practice, which may assist in forming a view as to what competency requires of a solicitor. But administration of funds is a very specialised and bespoke business, and it's an area where, of necessity, the judge has to look very carefully to base his decisions on the expert evidence. And he failed to do that. Now, Primeo, in its reply case at paragraph 28, and maybe I could just ask your lordships to turn that up. Paragraph 28, paragraph 2323, they seem to accept that the judge's conclusion was not supported by the expert evidence, but they say that's irrelevant and mischaracterises the position. They go on to say that ours themselves assert that Miss Bader expressed the view that R1 was negligent from 2002 onwards. Well, that's right, that's what she was saying. But that doesn't engage with the point that we're making, that there was no expert evidence to support the judge's bedrock conclusion that R1 was negligent from day one because a multi-source reconciliation was the sine qua non of a competent administration. So, my lords, that is the first point we make. I will briefly summarise the two other points and then just do a very quick wrap-up.
I'm afraid we do have to rise promptly today because some members of the court have another commitment.
I'm very happy to accommodate the court's convenience.
You've managed to fit a great deal into the time available to you today. Tomorrow we're going to start at 10.
Yes.
My reckoning of time is that if you have till 10:15, Mr. Gillis, then Mr. Smith will then have till 3:15 in the afternoon, and then you'll have 45 minutes to reply. Out of mercy to the court, we'll ask for an adjournment of 5 minutes or so, round about 11:30 tomorrow morning.